In 1995, a man in California stole a slice of pizza from a group of teenagers sitting outside a restaurant. He was arrested, he was charged, and a judge sentenced him to 25 years to life in prison for a slice of pizza. His name was Jerry Dwayne Williams. He was 37 years old, and what happened to him was not a judicial error, not a rogue prosecutor, and not a misapplication of the law. It was the law working exactly as it was written, a law that California voters had approved just 1 year earlier by one of the largest margins in the state's history. I am Ben. Today I am going to explain how a theft worth less than $1 can legally result in a life sentence, what three strikes laws actually do to people who are never violent, how the Supreme Court ruled that this is constitutional, and what it means for you if you have any prior convictions on your record at all. The case: May 1995, Redondo Beach, California. Jerry Williams walked up to a group of teenagers eating outside a pizza restaurant and took a slice of pizza from one of their plates. That was the entirety of the crime. He took a single slice of pizza. Police were called. Williams was arrested, and when prosecutors ran his criminal history, they found what they were looking for. Williams had 2 prior felony convictions on his record. Both were robbery charges from years earlier. Under a law California had passed in 1994, that made this pizza theft his 3rd felony offense. The law was called the 3 Strikes and You Are Out Act. And under its terms, a defendant convicted of any felony who had 2 prior serious or violent felony convictions on their record was to be sentenced automatically to 25 years to life in prison. No exceptions. No judicial discretion. The sentence was mandatory. The judge who sentenced Jerry Williams stated on the record that he personally believed the sentence was grossly excessive. He found it disproportionate to the crime. He sentenced Williams to 25 years to life anyway, because the law gave him no other choice. Williams's case became national news almost immediately. The image of a man going to prison for life over a slice of pizza was impossible to ignore. Late-night television covered it. Major newspapers ran the story. The public reaction was sharp and largely outraged. Eventually, a California appellate court found a procedural issue with the original sentencing. Williams was resentenced to 6 years and ultimately released. But the legal question his case raised did not go away, because Williams was not the only one. What 3 strikes was supposed to do. Before I explain what the law actually did, I want to be clear about something. Jerry Williams was not an innocent man. He had a prior record. He had committed robbery before. He walked up to a group of teenagers and took food from them. None of that is in dispute. The question is not whether Jerry Williams was a good person. The question is whether the law that sentenced him to life in prison for stealing a slice of pizza was a proportionate response to that act, and whether a legal system that produces that outcome is one that serves justice or just processes cases. Keep that question in your head as I walk you through how this law was built. To understand how this law came to exist, you need to go back 1 year earlier to a case that horrified the country. On the 1st of October, 1993, a 12-year-old girl named Polly Kloss was kidnapped from her bedroom during a slumber party in Petaluma, California. Her kidnapper was a man named Richard Allen Davis. Davis had a long and documented criminal history. He had prior kidnapping convictions. He had been released from prison just 8 months before the night he took Polly Kloss. Her body was found 2 months later. Davis was convicted and sentenced to death. The public was furious, not just at Davis, but at a system that had released him. The argument that emerged was straightforward. Some people keep committing serious crimes, regardless of how many times they are incarcerated. At some point, the state has a responsibility to take them off the streets permanently. If 2 prior serious felony convictions are not enough to keep someone like Richard Allen Davis away from children, then the 3rd conviction should be. California passed 3 strikes in March of 1994. It was one of the most popular pieces of legislation in the state's history. 72% of California voters approved it. The Washington state legislature had already passed a version weeks earlier. Within a few years, 24 other states had passed their own 3 strikes laws. The federal government enacted a version as well. The intent, as described by its supporters, was narrow and targeted. Identify the small percentage of repeat violent offenders who cause a disproportionate share of serious crime. Remove them from society permanently after a 3rd serious offense. Protect the public. That was the stated goal. Here is what the law actually did. And before I get into the cases, I want to note something about the political environment in which 3 strikes passed. The mid-1990s were the peak of the tough-on-crime era in American politics. Crime rates had risen sharply through the 1980s and into the early 1990s. Violent crime was a top concern for voters across the country. Politicians who were seen as soft on crime lost elections. Politicians who were seen as tough on crime won them. In that environment, 3 strikes was not just a law. It was a political signal. It told voters that their elected officials were serious about protecting them. And because it was a signal, the details mattered less than the message. The message was, 3 strikes and you are done. Whatever the fine print said about what qualified as a third strike, the voters heard something simple and satisfying. Laws built on political signals rather than precise policy design tend to have consequences their architects did not anticipate. California's 3 strikes law was no exception. What 3 strikes actually did. The problem with California's 3 strikes law was not the goal. The problem was the language. Most people who supported 3 strikes assumed that all 3 strikes had to be violent. The third offense that triggers the mandatory sentence would have to be something serious. Otherwise, the law would not make sense. That is not what California's law said. The original 3 Strikes Act required that the first 2 convictions be for serious or violent felonies. That part was clear. The third conviction, the one that triggered the mandatory 25 to life sentence, could be any felony: petty theft with a prior, drug possession, shoplifting an amount that crossed the felony threshold, anything classified as a felony under California law. And prosecutors had full discretion over whether to charge a new offense as a third strike. Judges had no discretion over the sentence once a third strike was charged. The result was a system where a prosecutor's charging decision, made before any trial, determined whether a defendant would go home in a few years or spend the rest of their life in prison. The cases accumulated quickly. Leandro Andrade was a 37-year-old man with prior burglary convictions. In November of 1995, he was caught shoplifting videotapes from 2 separate Kmart stores. The total value of everything he stole was $153.54. The items were children's videotapes: Cinderella, Free Willy, Little Mermaid. Because the thefts occurred in 2 separate incidents, prosecutors charged them as 2 separate felonies, each triggering a 3 strikes count. Andrade was sentenced to 2 consecutive terms of 25 years to life, 50 years to life total. He would not be eligible for parole until he was 87 years old, for $153 worth of children's videotapes. Gary Ewing was a man with prior robbery and burglary convictions. In March of 2000, he walked out of a golf course pro shop in El Segundo with 3 golf clubs stuffed down his pants. The clubs had a combined value of approximately $1,200. Third strike: 25 years to life. These were not the only cases. By the early 2000s, California had sentenced more than 7,000 people under 3 strikes. A large portion of those life sentences had been triggered by non-violent third offenses. The California Department of Corrections conducted an analysis of who was actually serving 3 strikes life sentences. Their finding was striking. More people in California prisons were serving life sentences under 3 strikes for marijuana possession than for murder, rape, and kidnapping combined. Let me be precise about that. Not total marijuana convictions. Life sentences. People who would spend the rest of their natural lives in prison. More of them were there for marijuana than for murder, rape, and kidnapping combined. The law designed to put away the most dangerous repeat violent offenders had become something else entirely. And the cost was real. Not just in human terms, but in financial ones. Each person serving a life sentence under 3 strikes cost the state tens of thousands of dollars per year to incarcerate. As those prisoners aged, their medical costs increased dramatically. California was spending hundreds of millions of dollars annually to house elderly, nonviolent prisoners whose crimes had been things like shoplifting and drug possession. The state was going broke doing it. A Rand Corporation study conducted in the late 1990s found that 3 strikes cost California approximately $5.5 billion per year. The same study found that the law's deterrent effect on violent crime was minimal. Other states that had not passed similar laws saw their crime rates fall at roughly the same rate as California's during the same period. The crime drop of the 1990s happened across the country, in states with 3 strikes and in states without it. There was no clear evidence that the law was responsible for any significant portion of that decline. What the law was doing, clearly and at enormous cost, was filling prisons with aging nonviolent offenders serving life sentences for minor crimes. The Supreme Court. The constitutional challenge was inevitable. The question was whether sentences like Andrade's 50 years to life for shoplifting violated the Eighth Amendment. The Eighth Amendment prohibits cruel and unusual punishment. The Supreme Court has recognized that the Eighth Amendment contains a proportionality principle, meaning that at some point a sentence can be so disproportionate to the crime that it becomes constitutionally impermissible. The question was whether three-strike sentences crossed that line. In 2003, the Supreme Court decided two cases simultaneously. Ewing v. California was Gary Ewing's case, the golf clubs. Lockyer v. Andrade was Leandro Andrade's case, the videotapes. In Ewing, Justice Sandra Day O'Connor wrote the plurality opinion. The court held, 5-4, that Gary Ewing's 25 years to life sentence for stealing golf clubs did not violate the Eighth Amendment. The reasoning was this: the sentence was not solely for the golf clubs. It was for the entirety of Ewing's criminal history. California had made a legitimate policy judgment that repeat offenders who continued to commit crimes, even nonviolent ones, posed a sufficient threat to public safety to justify long incapacitation. The court was not in the business of second-guessing those policy judgments, so long as they fell within a constitutional range. And the court found that Ewing's sentence, viewed as a sentence for a pattern of criminal behavior rather than a single act of shoplifting, fell within that range. In Andrade, Justice O'Connor again wrote for the majority. Andrade's 50 years to life was upheld. The court found that the California Court of Appeals' decision to reject his Eighth Amendment claim was not an unreasonable application of clearly established federal law. Andrade would remain in prison. Justice David Souter wrote the dissent in Andrade, joined by Justices Stevens, Ginsburg, and Breyer. He wrote that if Andrade's sentence was not grossly disproportionate, then the principle of proportionality in Eighth Amendment law was meaningless. 50 years for shoplifting videotapes could not be justified. It was 4 votes. It was not 5. The sentences stood. Leandro Andrade remained in prison. He was eventually paroled in 2019 after serving nearly 24 years for stealing children's videotapes. He was 63 years old when he was released. The racial reality. Any honest account of three strikes has to include who was actually sentenced under it. A 2001 report by the Justice Policy Institute found that black men in California were sent to prison under 3 strikes at a rate 13 times higher than white men. Latinos were sentenced at 3 times the rate of white defendants. This was not primarily the result of different rates of criminal behavior. It was the result of how prosecutorial discretion was exercised. Prosecutors in different counties applied 3 strikes differently. In counties with more aggressive charging policies, minority defendants were far more likely to have a new offense charged as a 3rd strike than white defendants in similar circumstances. The discretion that was built into the law, the choice that every prosecutor made about whether to invoke 3 strikes on a given case, was not exercised neutrally. And the cumulative effect of thousands of those individual decisions over years produced a system where the life sentence outcome was dramatically more likely for black and Latino defendants than for white defendants convicted of the same offense with similar criminal histories. This was documented. It was known. It did not change the law. The reform. In November of 2012, California voters went back to the ballot. Proposition 36 proposed 2 changes to 3 strikes. First, going forward, the mandatory 25 to life sentence would only apply if the 3rd strike was itself a serious or violent felony. A non-violent 3rd offense would no longer automatically result in a life sentence. Second, people already serving 3 strikes life sentences for non-violent 3rd offenses could petition the courts for resentencing under the new standard. 69% of California voters approved Proposition 36. The same electorate that had passed 3 strikes by 72% 18 years earlier voted nearly as overwhelmingly to reform it. What changed? 18 years of data on what the law actually produced. Not what it was supposed to produce, what it actually produced. When voters saw the numbers, when they saw Leandro Andrade's 50 years for videotapes and Jerry Williams's life sentence for pizza, the political calculus shifted. In the years following Prop 36, approximately 3,000 people who had been serving life sentences under 3 strikes for nonviolent 3rd offenses petitioned for resentencing. Most of those petitions were granted. 3,000 people who had been serving life sentences, some of them for years or decades, were released. 3,000 people. 3,000 life sentences for nonviolent crimes. 3,000 people for whom the reform came only after years or decades of incarceration. Jerry Williams had been released years earlier because of a technicality. Leandro Andrade was still in prison. He would wait another 7 years after Prop 36 passed before he was finally paroled. What this means for you. 3 strikes laws still exist. California reformed its version significantly in 2012, but that reform applies only going forward to new offenses and to people who could petition under its terms. The federal 3 strikes law still exists. More than 20 states have habitual offender laws that function similarly to 3 strikes, with varying structures and trigger thresholds. The single most important thing to understand is this: prior felony convictions do not expire for purposes of sentence enhancement in most jurisdictions. A conviction from 20 years ago can still count as a prior strike today. The record follows you. If you have any felony convictions on your record, you need to know 2 things. First, whether the state you live in has a 3 strikes or habitual offender law. Second, what specifically triggers enhanced sentencing under that law, because the rules vary significantly by state. In some states, all 3 offenses must be violent. In others, only the first 2 need to be serious, and the third can be anything. The difference between those 2 structures is the difference between a manageable risk and the possibility of a life sentence. The second thing to understand is how prosecutorial discretion interacts with these laws. In jurisdictions where prosecutors have the choice to charge a new offense as a strike offense, that decision is made early in the process, often before any plea negotiation begins. And once a charge is filed as a strike, the leverage it creates in plea negotiations is enormous. The defendant knows that going to trial and losing means a mandatory sentence. The pressure to accept a plea deal, any plea deal, can become overwhelming. Your attorney needs to be tracking this from the first moment of any new case. Not just what the current charge carries on its own, but what it carries in combination with your existing record. If the state you are in has an enhanced sentencing law, and you have prior felonies, the calculation of what a conviction means changes completely. There is also the question of what you plead to in any current case. If you accept a plea to a felony that counts as a strike, you are locking that prior into your record permanently. Every future charge carries different weight. Understanding that before you sign anything is not optional. One more thing that is worth knowing. In some 3 strikes jurisdictions, prosecutors have the ability to offer to dismiss a prior strike as part of a plea negotiation. This is sometimes called striking a strike. It requires the prosecutor's agreement and, in some states, a judge's approval. It is not guaranteed. But it is a tool that exists and that your attorney should be exploring in any case where you have prior strikes and are facing enhanced sentencing exposure. Silence on this issue is not neutral. Attorneys who do not specifically raise and address your strike exposure are not fully representing you. It is something you should ask about directly, in writing, so there is a record that the question was raised. The complete picture. Here is what I want you to take away from Jerry Williams and the pizza slice. The 3 strikes law was passed for a real reason. Richard Allen Davis was a genuine danger. The public's demand that repeat violent offenders be incapacitated permanently was understandable and, as a matter of policy, defensible. The failure was in the implementation. By making the mandatory sentence trigger on any 3rd felony rather than a 3rd serious or violent felony, California created a system where prosecutors, not judges, determined who would spend their life in prison. By stripping judges of all discretion at sentencing, the law made it impossible to account for the specific facts of any individual case. By distributing charging discretion unevenly across racial lines, the system produced outcomes that had more to do with who you were than what you did. The Supreme Court looked at 50 years in prison for shoplifting videotapes and said it was constitutional. 5 justices found a legal theory that permitted the sentence. 4 justices said it was indefensible. That 5-4 split, and what it meant for Leandro Andrade's next 24 years of his life, is a useful reminder of what constitutional limits actually do and do not protect you from. The Constitution sets a floor. It does not guarantee fairness. It does not require that sentences be proportionate in any intuitive sense of the word. It requires that they not be so extreme as to cross whatever line 5 Supreme Court justices happen to draw at any given moment. For everything that falls short of that line, You are inside the discretion of a system that has shown, repeatedly and documentably, that it exercises that discretion unequally. Jerry Williams stole a slice of pizza. He was wrong to do it. He had a prior record. He was sentenced to 25 years to life. Leandro Andrade stole children's videotapes worth $153. He was sentenced to 50 years to life. The Supreme Court said that was fine. He spent 24 years in prison before he was paroled at 63. These are not anomalies. They are what the law produced, at scale, for decades. Understanding how the law actually works, rather than how it is supposed to work, is the only way to protect yourself when it comes for you. If you found this video useful, subscribe. I make one of these every day. There is always another case worth knowing about. I will see you tomorrow.